Good morning, board members. Today is April 21st.
This meeting is being transcribed. This meeting is being recorded.
Thank you. Good morning. Today is Friday, April 21st. This is the regularly scheduled Court Reporters Board meeting. I will take agenda here to get us started. My name is Roxana Gamusio. I'm the Executive Director with this board. If when you hear your name, you could please respond. I'd need to make sure that we have quorum for the meeting. Ms. Stephanie Branham?
Here.
Thank you. Britton Collins?
Here.
Ken Mansfield?
Present.
Brandon Peets? Ms. Morgan, Marilyn Morgan is not with us. Judge John Rambo is also absent today, and Coria Neal is also absent. We have 4 members attending, so we do have quorum and are able to proceed. Notice of this meeting was originally posted for the March 24th, 2023 date. The meeting had to be rescheduled to today, April 21st. The notice for this meeting was posted as far as the date and time, and the agenda were updated on the board's website as of April the 12th. The agenda has been emailed to all of the board members ahead of this meeting. It's also the first item on your presentation. If you see any need to make any changes, please let me know. Otherwise, I need a motion to accept the agenda as it's been posted and presented.
So moved.
You have a second? Thank you. We have a motion by Mr. Collins and a second by Mr. Peets. All those in agreement, please say aye.
Aye.
Any opposed? Thank you. On your presentation on your iPad, starting with page 2, you have the December meeting minutes. Those were also emailed to the entire board to review ahead of the meeting. If you would please take a minute. If there are any changes to it, I'm happy to address those. Otherwise, we would need a motion to accept the December meeting minutes and post them to the website.
I make a motion to accept the minutes of the December 9th, 2022 meeting.
Second.
Thank you. We have a motion by Stephanie Branham. Was the second from Ken? Oh, Mr. Collins. Thank you, Britt. And a second by Mr. Collins. All those in favor to accept the December meetings, please say aye.
Aye.
Any opposed? Thank you. Our next order of business, being that this is our first meeting for the year, would be to agree to follow Robert's Rules of Order. If you have any questions on those procedures, I will turn it over to our attorney, Hugh Cross. Otherwise, I would need a motion to accept following those rules and then a second.
Make a motion, we accept the rule.
A second.
We have a motion by Ken Mansfield and a second by Stephanie Branham to follow the board meetings and proceed following Robert's Rules of Order. Next, as our statutory requirement, being the first meeting of the year.
On the motion.
Pardon me. Thank you. For all those in favor of following the motion for Robert's Rules of Order, please say aye.
Aye.
Any opposed? Thank you. For our first meeting, we need to elect our chair, vice chair, and secretary. I will take any nominations. Currently, we have Ms. Stephanie Branham as chair. Our vice chair is Brandon Peets, and our secretary is Marilyn Morgan. We will need to fill all 3 of those positions again.
Eligible to serve in the same roles. I think by statute they can't more than 2 years in a row. I can't recall who was last year.
Right. I don't have the 2 years in a row, Stephanie. I don't believe you've been 2 years in a row. I don't think you would have been either, Brandon. So to my knowledge, at least the 2 are fine.
And I think Chancellor Rambo was the chairman last year, right. I believe. So if he's in the secretary position, that'd be his first year there.
And he's not. Marilyn Morgan is.
I'm sorry. So, okay.
Yeah.
I'm not sure about that.
Yeah. So I think our 3 are in the first. Marilyn, I believe, was the first year as well because she thought she would be taking minutes. She had a question about that, so I don't think she's had it before either.
So I move that we elect, or I guess nominate the current slate of officers for a second term.
Second.
Perfect. So we have a motion by Britton Collins and a second by Ken Mansfield to nominate the individuals that are currently in those positions. That would mean Stephanie Branham as chair for one more year, as vice chair Brandon Peets, and our secretary Marilyn Morgan. All those in favor, please say aye.
Aye.
Any opposed? Thank you. That takes care of our board meeting items. Next on your iPads is just an update. This is regarding our budget and our financial information. At the December meeting, we were able to look at the fiscal year closure for 2022. Right now, before you have our expenses through February of 2023, and that is adding a deficit of $27,116 to this particular year. And so it brings down our ongoing reserve to $164,589. Again, this is an off year as far as renewals are concerned, so that is to be expected. Our licensing numbers as far as the revenue are down a little bit, but nothing out of the ordinary for this particular cycle. Any questions regarding our information? Thank you. I want to give a quick update. At the December meeting, we talked about the ID cards with the photographs. They have not been printed or released yet because we're going through a massive change in our computer system. We're going to be working exclusively on the cloud and changing the online application process as well as what we do behind the scenes. Technology is amazing, but it takes a lot of testing and issues. And so at this point, we can't retest those items to release them. So I wanted to update everybody, but the only change we've made to what we've done in the past is taking off the expiration date. We're going to treat it similar to attorneys. If attorneys don't need to have an expiration on their cards, this would work the same way because this is going to be a courtesy print at no additional expense to our licensees. And so we definitely can't charge for them to be redone. So it'll be a one-time, but we're unable to test it this time. I don't have an idea if that'll be able to be done by July or August. As soon as our system rolls over and we're able to, and all those things work perfectly, then we'll start testing to release this. So hopefully by the September meeting, I'm able to give you an idea of when it goes out. I am going to turn it over to our attorney, Hugh Cross, to go over the legal report and other items that he has.
Good morning. Before we get to the legal report, I just want to give a brief update on sunshine laws. I'm going to give a full presentation at the next board meeting. It was not ready for this meeting. I just want to make sure that just moving forward that we're aware of sunshine laws, open records, Open Meetings Act. I'm sure you all are, but I just want to give a statement on that. So please keep in mind that all discussions, including discussions regarding complaints, must be made on the record. Please do not discuss board business outside of official board meetings. This includes discussions with members of the public, industry professionals, or complainants and or respondents to complaints. For example, if a complainant reaches you directly, one of you directly, to discuss a complaint, you should refer the complainant to the board attorney or executive director to handle. Complaints are presented to the board anonymously. If any board member has discussions with a complainant or respondent regarding the facts of a complaint, the board member is expected to recuse from any discussion on the complaint when presented. You may also refer back to the board member orientation manual. I don't know, does everyone have a copy of that? It has a pretty good breakdown of what you can and can't do. It also discusses unreasonable restraint of trade and conflicts of interest. So, like I said, I'll give a full presentation at the next board meeting. It should last 20, 30 minutes. I won't bore you too bad, I promise. It will include an overview of the Open Meetings Act, also known as the Sunshine Laws, and Open Records Act. It will also touch on how to avoid conflicts of interest and unreasonable restraint of trade. And that's all I have for the Sunshine Laws presentation. We can move on to the legal report unless there's anything else on the Sunshine Laws portion. All right, let's move on to the legal report. There are 2 cases. They were fairly straightforward, but I'm here to answer any questions that may come up.
question for the reporters on the board. Is it common to the line in here about respondent stated that an additional fee would be required for the read and sign since complainant no longer wanted to purchase the transcript? Is that common? I mean, if that's the part of this that bothers me the most. If the deponent has a legal right to review and sign the transcript and to waive it at the moment of the deposition under Rule 30, but nevertheless has the statutory right to sign it later, then seeking to charge the deponent for exercising a right that they have under the rules of civil procedure seems odd to me.
Yep.
And then kind of refusing to allow the deponent to exercise the right that the deponent has under the rules of civil procedure.
My understanding with that is they have a right to the final transcript, but it's if the proceeding is done and the party requests a transcript, it's the final transcript that's available. I mean, if this, my understanding with this complaint was that the gentleman had ordered a transcript and then decided he didn't want one. I don't know if that had to do with opposing counsel ordering it expedited or not, but there's an issue there where he no longer he wanted to wait to sign the transcript, which wasn't, he was supposed to sign it after the hearing and then decided not to. And then there was a communication delay. So the court reporter has a duty to issue the transcript. I mean,
Sure.
You can't wait on the party to sign. That's my understanding.
Sure.
It's rather confusing to me because you don't sign after the deposition or the hearing. You sign after the transcript is complete.
So what's the normal process if a court reporter finishes a hearing? If they don't sign, what's the time frame that they should sign?
You have 30 days within which to sign the transcript after the transcript is completed,
Right.
not at the end of the hearing or the deposition.
Once it's complete, the final
Once
transcript.
it's complete,
Right.
the final
But
transcript.
that doesn't mean it can't be issued. The transcript can still be issued to the other party, but they don't wait 30 days for an expedited transcript. I mean, I've ordered those myself. So I guess the issue is if the opposing party decides that they don't want to sign or they want to wait the full 30 days, does the party requesting the transcript have to wait?
No.
Right. So that's
The one who orders the transcript gets the transcript.
right.
If the copy side is the one who wants to read and sign, they have 30 days within which to do it. But if they've ordered a copy and then they decide they don't want a copy, they won't get a copy, but the other arrangements will have to be made for them to read and sign their deposition.
Right. So it's the $50 additional fee that's
No, I've never heard of a fee.
I have neither, but there's nothing in the rules against it that I saw. There's nothing in the statute against it. I mean, if you can direct me to something that says you can't do that, but it was also, there's a mobile aspect to it. So
You can do it over Zoom. You can have them look at the transcript on Zoom with you, or you can send them an email of the transcript that can't be printed. There's a number of ways that you can do it, or they can come to your office. No one says you have to go to them.
I think that was the request here. I'm not, but this court reporter is not, my understanding is they're mobile. So there's not an office to go to, or there wasn't in this case. It wasn't available. I'm still not seeing this as a violation, but if you can explain why it would be a violation, I can adjust the recommendation. But I've looked at this, upper legal's looked at it. I mean, I agree with you. For a mobile sign, I think was the issue is sort of an administrative cost. This gentleman had ordered the transcript, then decided not to, and in this particular case, or this court reporter generally will waive the $50 administrative fee for the mobile sign as long as they order a transcript. This gentleman no longer wanted to order a transcript, so
You know, this is a Tennessee-based reporter.
it is.
I've never heard of having a fee to read and sign.
That's good to know. I mean,
I think that it's their right to read and sign their transcript,
it is, but
whether they
it's-
get a copy or not.
Yeah, I mean, this gentleman, he can still read and sign it, but the expedited transcript was already ordered, so it's final. When the court reporter has finalized it, it's final. So the read and sign can still continue. Now, if, after 30 days, if there's a additional complaint, or if potentially we could adjust the recommendation that, I could check in and see if the read and sign happened, but he doesn't have to read and sign it if he decides later. So I don't really know how to police it. You know what I mean? If you close this complaint and another complaint is open for this, and now it's 30 days past and something has changed, then we can reopen the complaint, or not this, we can adjust. We'll have a new complaint based on the failure to read and sign. This one was about the mobile $50 fee. I don't see in the rules or the statutes that would prohibit a court reporter from doing that. Now, it could be some communication there between the court reporter and the client, but it's not something I can police. I mean, everything looks to be in order. It just, something happened with a breakdown of communication here. So,
Well, it's a whole breakdown here because the complainant ordered the transcript copy, and then when they got the invoice, they decided they didn't want it.
right.
So,
But it's my understanding court reporters can charge for any ancillary services they see fit to. So, yes, they have a right to read and sign, but, I mean, there's nothing that I'm aware of that prohibits them from charging.
Right. And there could be an unreasonable aspect of if the price was way high,
Right.
or if she said you have to do the $50, that's the only way. My understanding was the issue was he ordered the transcript and then decided he didn't want it, and there was already sort of that going on, that aspect going on, and then when they tried to make an arrangement for the mobile sign, I don't know if it was the respondent that couldn't get there or the complainant that couldn't get there, but somehow or another the arrangement wasn't going to happen unless the $50 fee was paid. But I'm looking at it, the issue is whether this court reporter got in the way of the read and sign, and the fee associated with it. The gentleman has a right to read and sign the final transcript once it's final. But if another party orders a transcript, that's the transcript that's going to go. He can still conduct the read and sign, but there hasn't been any follow-up communication with that.
I guess that was my question. Did the complainant ever get the opportunity to read and sign their transcript?
I don't know. It's my understanding is they've stopped communicating. So there's no more. I guess the court reporter has emailed this gentleman, and there's been no response, and so there's no more communication at this point. Just the complaint.
But I understand it, the crux of the complaint is that well, at least the complainant believes that this $50 fee sort of burdens their substantive right to read and sign. But as you've stated, I mean, the fact that the party taking the deposition actually ordered an expedited transcript doesn't take away this individual's right to read and sign. So I guess I'm trying to understand what the purported violation is here. So I guess is the issue whether the charging of the fee is reasonable given its implications for this substantive right?
Well, this is why the way I look at it is there's two issues. The one is the fee. The second one is the substantive right. I think the court would have the authority to determine whether this civil procedure was broken here. That would be my understanding. That's my understanding from those from upper legal as well. For the fee, I'm solely looking at the rules in the statute to see if there's something that would prohibit the fee, because I think that the overarching issue was the gentleman ordered the transcript, decided, and there was no fee at that point, decided he did not want the transcript, and then the fee was tacked on. And my understanding from the respondent is that this fee is their standard practice for solely read and signs. If there's a transcript ordered, there's no additional fee. But in this case, since he backed out of the transcript order, there's this additional fee that's always $50 is consistent with this respondent. I didn't see anything in the rules or statutes to prohibit it. That's, if there's something I'm missing, please let me know.
Well, I know that the law reads that upon payment of a reasonable fee, any party can get a copy of the transcript. But I'm not aware of any reading of the law where it says upon payment of a reasonable fee, someone can read and sign their transcript.
Right. He could still sign his transcript. I mean, if it's within the time frame. My understanding is there was communication between them and then it stopped. So the respondent was reaching out, the complainant reached out about the $50 fee, did not want to pay the fee. They tried to coordinate the mobile sign. They couldn't do it. The respondent tried to connect with the complainant multiple times, and there's just been no more communication after the fact.
Well, the problem we get into with this, and I don't want to overcomplicate it, but if after the 30 days they haven't read and signed and haven't made a diligent effort to do so, it's as if they did read and sign, the transcript stands. So I don't know how you, I don't want to overburden it, but here we are.
It's a little tough in that regard. Yep.
So
sometimes, when the complaints come in, there's a procedure before, I see them. They go through centralized complaints and so that's why I think the court would be a better authority over this, because if it's after 30 days or it's not, I mean, that's not really, I don't know what I would cite to this individual as a violation. Even if it was after 30 days, I would most likely have to request the board to refer it to the court. I mean, that would be my thought, unless there's something else in the rules that would, justify like maybe a, untimely or unprofessional or something like that. But it's kind of a sticky area.
I'm looking through the standards of professional conduct and our rules and regulations, searching for something similar. The only thing that, I think that you could try to wedge it under would be subpart A on just the general obligation of fairness and impartiality towards participants. Is this fair? That's a slippery slope that, I don't know that we necessarily want to go down, trying to decide, what's fair and unfair in every scenario, and then trying to kind of ad hoc create professional standards through a fairness rule. So yeah, I similarly struggle, although I don't like it, I similarly struggle to find a rule that's been violated. So unless anyone else has anything they want to add, I would move to accept council's recommendation to close the complaint.
And I'll second it.
Thank you. We're voting then on complaint number 1 that was discussed. We have a motion by Mr. Collins and a second by Mr. Mansfield to accept legal's recommendation to close it. All those in favor, please say aye. Aye. Any opposed? Thank you. That is our first complaint. If you have any questions on the second one, by all means, if not, we'll vote on that one separately as well then.
To me, this one seems pretty straightforward. It's a billing dispute, and that's just not part of our jurisdiction.
I get your mic.
Oh, is it not? Oh. So unless there's any other questions, I would make a recommendation to accept the
Do we have a second or any further conversation?
I'll second it. Also, I'm going to say this almost rises to the level of a frivolous complaint.
For complaint number 2, we have a motion by Ms. Branham and a second by Mr. Mansfield. All those in agreement to accept legal counsel's recommendation to close, please say aye.
Aye.
Any opposed? Thank you. Thank you, Hugh. That takes care of our legal report. I believe before we go on to new business and seeing if there's anything else the board members or anyone here wants to discuss before we open to that, I think on our Teams meeting we have someone with a raised hand, and Dana, we can unmute them. I just want to make sure if it's already been addressed that if there's anything new, we welcome the participation. If it's about a complaint, please always remember complaints are redacted. The board members do not know who the complainant is. They do not know who the complaint is against. So that is important to maintain. But if anyone has any questions, please go ahead and unmute yourself. Thank you. Dana, I just want to make sure that you can hear. Is everything okay, or did we have any other raised hands?
The only raised hand that we had was Patricia. She's on the Teams call.
Okay, and her hand's gone down. We're good? Okay.
No, her hand is still raised, but she's not unmuting herself,
Okay.
and I'm unable to unmute her.
No worries. We will proceed, and before we close, if anything else comes up, just send a quick note. I think Katie can see it. Thank you. Board members, anything? I have nothing else under new board business. If you have anything at all to address.
I would like to bring up one thing. We have lost one of the original members of the board this year. And in fact, our first chairperson, Jimmy Jane McConnell, who passed this year. And I did not want to let this opportunity go by without announcing that and recognizing her for the good work that she had done for the board and for the reporters of the state of Tennessee. And she will be greatly missed by all. Thank you.
Thank you for waiting. Very important. I think unless the board has anything else to address. Yes, that's why I said, yeah.
Okay. Well, I'm not really sure what I'm supposed to do.
If you'll make sure. Sure. Well, if I.
Hi, my name is Sheila Wilson, court reporter from Chattanooga, and thank you so much, Mr. Mansfield, for recognizing JJ. She was a great asset to this team and to this board, and did a fabulous job with enacting licensure and establishing this board. So thank you for that. I get a little emotional because JJ and I were pretty darn close. So I did have some things to say, and I'm not going to, but I would ask the board's consideration going forward to just keep in mind perhaps a couple of things, and that is, and I will keep it very short, pursuant to TCA 20-9-605, which is considered the Tennessee Court Reporting Act, it provides that the board shall have the duty and responsibility to act on matters of licensure and the process of granting, suspending, reinstating, and revoking a license. And I say that, and I ask the board to perhaps consider going forward developing maybe a mechanism whereby applications that at first blush may not fit the four corners of what qualifies to obtain a license, and where there may be a question, that maybe the board consider developing some sort of committee to take a look at those. I'm not asking the board to look at every application, by no means, but as an example, if you are submitting an application for an electronic court reporter license, there There are certain things that you have to, there's a standard that you have to meet. If you're a voice writer, there's a document that you have to submit. If you're a steno writer, there's a document that you have to submit. Those programs, or whatever you want to call them, for folks that are not in the industry, I'm sure it can be very complicated, and I appreciate that. However, as an example, I'm a court reporter. I can tell in 2 seconds if I'm looking at an application of either of those three methods, ER, voice, or steno. I generally know what the rules are, and I know what the qualifications mean. I can tell in 2 seconds whether or not the document that they submit meets that standard. The program, or whomever it is that is issuing license, may not have that. I'm not saying they do or don't. They may not have that awareness. So when an application comes in and it doesn't say AAERT for American Electronic, whatever that is, or voice writers from the National Verbatim Association, or NCRA, that at least those few applications are passed along to someone on the board. It could be a little subcommittee. I think you have that ability to make those types of recommendations. And secondly and finally, when disciplinary matters are brought before the board and the board enters into a consent order, I would respectfully request that someone on the board, could be a chairperson, we have wonderful attorneys and a judge as well, just to cast eyes over the final language of that consent order to ensure that it comports with exactly what you voted on. And I think that is fair, and I think that is quite within your discretion. And that's all I have to say. And thank you, all of you, for your service, and I appreciate it. Have a blessed day.
Thank you. Thank you very much. Members, have anything else? Otherwise, we are good to adjourn.
Well, I do have some things to say about that. I have people come up to me, attorneys and attorney staff, talking about, quote, digital reporters who are showing up on depositions and in courts. And I wonder, do they have a license? If they have one, how did they get one? Because there are certain parameters that have to be met. And if people are getting licensed who are not supposed to get licensed, the board needs to be aware of that. And the board needs to be able to take action on that.
You know that our licenses can be looked up by, we know judges on occasion will reach us and they look them up all the time. So it's through verify.tn.gov. If they're not in their license, because that's real time, then you would file a complaint. We have court reporters that file a complaint. That individual that knows directly that they're doing that, that is how we would find out and be able to do anything. Without that complaint, we really can't do a whole lot.
I think, and maybe I'm not understanding, but I think the crux of what we were discussing is more, how are they getting the initial license approved? And are they meeting the standards that those applications require?
Everything that's in the rules that sets what's required, the education and the exam, that's what's being reviewed. We don't review a transcript that they've put together.
Who reviews it?
I do. Katie does. Katie's here because she does licensing. I'm here because I approve. We are the program and that piece. If there's a concern with an application, we would discuss it with legal to see if we have any jurisdiction and there's not enough there. And then if there's a concern, it would come before the board. That has never changed. And I think at the last meeting, we discussed the digital. So if you know of someone, and this is for every industry, we've got 27 under Commerce and Insurance. I'm the director with 9 of them. If there's a complaint or unlicensed activity, the way that's reported is through the complaint process so we can review. If it's a court reporter, they're probably doing documents for a law firm or a judge. That has major repercussions. So it's an easy complaint to try to follow up with at least. But if we don't know because it doesn't come through the complaint, back to the information that Mr. Cross provided, you probably won't need to do the research, but you're able to even file the complaint. We have board members that, have direct knowledge. They recuse themselves for the complaint when it's presented, but you can file the complaint yourself.
It would be nice if it was easier to search the database of licensed reporters too.
The last
It's
name
somewhat
and first
obscure to
name.
try to
Really?
find it. It
Okay.
is.
Okay. I will make sure maybe after the meeting, Ken, to give you a call because it really is select the program and then a last name.
I know, but if you don't know a name, I'm
Oh,
just
yeah.
talking about just a list of all the reporters who have a license in Tennessee.
Oh, absolutely. That is called a public records request. It's available online to all Tennessee residents. We release one or two, Katie, a day for our different programs. So all court reporters, law firms can request those. You would tell us if you want email, phone number, address. Those have been available online for years. And not only for court reporter, but businesses require those, right? And ask for them to market to you all. And I'm sorry, but that is releasable data. Yeah.
One more question, and I'm
Yes.
sorry. We have to, when we submit an application, show what form of reporter we are, whether it's machine, voice, or electronic. On the database, it does not define that, does it?
On a Tableau report, I can pull that information. That is a special modifier. If you just search under verify, no, you just see that they're licensed. Now, you just said that these people aren't licensed. You'd see
Well, I
that
don't
they
know.
have one. Yeah.
I don't know.
Yeah. So if you search them, you'd see that they have one or don't. That was findable. But if you need a report that then pulls what type of court reporter they are, that is a report that we would run and be able to issue. And those are at no cost to Tennessee residents. It's an Excel report. Again, even marketing firms sometimes request those.
Concern I have is perhaps they do have a license, and they should not have a license.
Can I
That's
add
what
to that,
really
Mr.
concerns me.
Mansfield? Do you mind if I add to that? So I've noticed that too. There will be people that will submit applications and they'll try to submit a digital reporting. We don't approve that. What that digital reporting is, from what I've noticed, is it's some exam that NCRA or NVRA they have, and basically we we don't approve that. But it's a prerequisite for when we do approve. So they're taking this digital portion and then trying to submit applications, and then I'll come back and say, hey, we need a certificate for the designations we do approve, and they're sending the certificate because that digital is like a prerequisite for what we do. But they could take that digital and then never take the CER or whatnot, and then we can't approve that. Does that make sense on that? I've noticed that, though. They'll try, but we don't approve it.
Well, are they getting a temporary license?
No, they are not.
No, they're submitting what then they need to get an initial license, but they're trying to use the digital as that entrance, and it's not that.
I'm happy to send all the members the link to the public records request, or you can email me and I'll be happy to send that to you. Hopefully those reports will be helpful.
That would be helpful.
Yeah, they're out there.
I have a question, if you don't mind. On your first point about maybe applications that you're alluding to, there being applications that maybe at first blush don't appear to meet the requirements. You're speaking kind of generally about that, and I get you're trying to be polite, but
of course.
can you give a more specific example of what you're talking about? Because I want to make sure I understand the concern that you have.
It is a concern, and I will tell you that navigating, and thank you for the explanation on the Excel spreadsheet. I thought it was just a PDF, but trying to navigate the online system is somewhat challenging. I did notice above that verify thing, there's another tab that you sent that is there. I can't remember what it's called, but it does give a little bit more information. But it is an ongoing concern, Mr. Collins, that can I stand here and say that someone submitted an application saying, we'll make it up? I graduated, that I attended a 2-week course from ABC Digital, blah, 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 and I'm submitting that with my application, and it's being accepted, and I'm getting a license. Can I say that? The answer is no. But I appreciate the lady to my left giving that explanation that they oftentimes, it seems, the program gets information or applications that may not qualify for a license. And what I'm saying is, for the program, they're not boots on the ground. We know what things are supposed to look like. The reporters on this board know what certificates are required and what educational requirements are required. It can be a little more complicated, and that, in fact, is what I was concerned about. And additionally, whether or not, if someone, as an example, in whatever year got a license under a grandfathering and they let that lapse, does that qualify for them to get a brand new license? That I don't know. I can read the rules, and I have certainly my interpretation, but the program may have a different interpretation, and the board may have a different interpretation. But it seems proper and prudent that someone cast eyes on that. And is that sort of answering your question, sir?
And I appreciate you clarifying, because I had misunderstood your concern I thought you were concerned that people were getting denied when they shouldn't, but in fact your concern is there might be people who are getting approved
that is
who should
correct.
not. Okay.
Correct. And I haven't found anything on the website, and to be fair, it may be there, but navigation is challenging to submit or check, get an Excel spreadsheet of only, as an example, expired license in the last 6 months, steno only. There are certain modifiers that one can key in, but getting the information you just have to kind of play with it and think. I think I've generally figured it out. Like as an example, fairly recently I looked for expired license, and I keyed in a certain period of time. It mattered not to me the method, but I did do court reporting, expired, I think in the last 12 months is what I looked at. And then I looked to see if they had been issued a new license, a different number. Now, it took me a little wiggle room to figure that out, because I had to print individually or make a list individually of each person who had a license expired, and it does give their number, their first number, their license number, and then you can click a little further and you can find the method. And if you click a little further, you can see, I think it says grandfathering, if they were grandfathered. And then I cross-referenced that and just typed in those person's name, and to see if there was a new license issued under a different number, but the same person. Is that making sense? And whether or not that potentially was under a grandfathering that expired some period of time.
And I will just reiterate, the public records request form is what you want. I'll be happy to send you that. That has everything you need.
But I would have to ask, okay.
Yeah, it's just an online request.
Sure.
And
Okay.
I think that'll save you the time, right, of searching that later.
Well, I was trying to figure out how to navigate it myself so as not to, and I don't want to have to come to you to,
No,
every
it's
time.
online.
That's just ridiculous. That's what the service is for. But we all ought to be able to do some cross-referencing
Yes.
on that.
Right. I think, Roxanne, your point is you have the ability to do additional filtering on the back end that isn't available
The verified
on the front end.
report
And
is
so if
there.
she's looking for more granular
Yes,
detail like
absolutely.
that.
It is the
You-
public records request report. Really, that way you can easily in Excel filter what you need, and so that's what I would recommend. Yeah, and I'll make sure that she has that link. But for you also,
I think I know where that public. I've used that before, and you've been good. So
Appreciate
does that
your
understand?
yeah,
Does
thank
that
you.
answer
I
your question?
appreciate you.
Thank you.
Thank you.
One thing else, she brought up a point about someone who had gotten a license under the grandfathering provision and then looking for a new license number. Well, I understood, and we've had several discussions about that. If someone lets their original license lapse, and if they apply for a new license, they have to meet the requirements that the law outlines that they have to meet to get a new license. You can't go back and reinstitute the license they had under grandfathering because it no longer exists. Now, am I wrong about that, or am I right?
No, that's correct. Sorry, I'm trying to reach here. But the statute requires proof of education or testing for those. So not necessarily, I think the discussion was about testing. If there's proof of education, that there's no retesting for that.
Well, I'm thinking about if they want to get a new license, though, the education wouldn't have anything to do with it. It would have to be that they have to have this licensure, or not licensure, but they'd have to have these qualifications from these 3 recognized bodies, educational
Well,
bodies.
as long as there's proof of education, as long as they have proof that they've taken the exams. That's what I mean by education. Just not simply making someone retest. If they've
passed the exam.
If they've taken the exams, right?
And passed the exam.
Right.
I mean, if somebody was grandfathered and they let their license expire at some point, and then there's a grace period, right, where you can get is it 6 months, the grace period?
6 months, yeah, and then there's...
And then if you get outside of that, then you have to apply for a whole new license. And
Right.
so that's where I had one license number and now I have a new one. It's because I let my license lapse. I fell outside of the grace period. Now I have to apply for a new license just as if I was a brand new court reporter fresh out of school. And I would have to be able to demonstrate the same credentials as a brand new applicant. And
Right.
then I would be issued a new license with a new license number.
As long as they show proof of testing, successful testing, I'm not going to send
Under the statutory standards and not
Right.
under whatever
Right.
they had been grandfathered in from back in
Right. Well, the grandfathering
2009 or
is
whatever.
a piece for the department because it's a property issue, so that can factor in. But my understanding is new application if you're outside the grace period, if there's a new application, then you have to show proof of education. Well, I say education, I mean testing, proof of testing, proof of education. You submit that, you get the new license. That's my understanding. So.
My understanding is you have to pass the RPR or the CVR or the AAERT-CER exam to get a license. That's the only provision we have these days.
Oh, that's what I'm saying. That's what I'm saying. Instead of spelling them all out, I'm saying if you meet the education standards, the testing standards, we're not going to force someone to do it again.
I understood you to say that grandfathering had an element.
No, there is an element for grandfathering for licenses that are already issued. That I'm saying there's an element there to consider that this department considers. If licenses are issued, there's a property aspect to that license, so it's something we have to take into account. But it's not going to get rid of the testing aspect of it. That's it, but it's still something we have to consider because this board is unique in that regard.
Sure, but once a grandfathered court reporter allows their license to expire and then falls outside of the grace period, they have surrendered whatever property right they had in their initial license.
They haven't surrendered it, but there's my understanding is since the statute requires the testing, as long as there's the proof of testing there, they get the license again.
That's no different than if I'm, Joe Blow and I walk off the street. Again, I just graduated from court reporting school. I've taken the tests.
Right.
I mean, I have to meet the same standard.
That's the department policy. Yeah, that's what I'm saying. But if someone who has a license that decides that it's expired and they apply for a license and they were to sue the department, that would be the argument. Would be that they were grandfathered in, they had this license before, it's a property right. The federal Supreme Court has discussed this on numerous occasions. It's not something that we're saying has to happen. It's an element that we consider in the sense that maybe there needs to be a statutory change, a rule change, something to address it more clearly so that we can get rid of that aspect of it, at least from the department standpoint, because we don't want, someone that would normally get in with a $250 consent order civil penalty being denied a license and having to pay thousands of dollars for testing. If they sue the department or some sort of legal action takes place, that will be the argument. Now, my understanding is the statute still stands, so there would be a new application. We have to see the proof of testing. However, I'm saying there's an element to consider there. That would be the legal argument that they would make. But that's the end of it. I mean, that's the consideration.
How many? I mean, we're talking about maybe it's not as small of a subset as I'm imagining it is, but I mean, we're talking about the folks who got grandfathered in at the initiation of the Court Reporters Act in 2009?
2010, I think it was the first year.
Right. So it was, folks who had met a certain standard at that point, they got grandfathered in, so they didn't have to meet the new statutory requirements. And I mean, how many of those are there?
We can run it.
Remaining
I don't
at
have a
this
problem.
point.
Very, probably few, but so you are correct that it's few that are still in that caveat. Yeah.
it still concerns me when you say that grandfathering has an element, because grandfathering,
I think what he refers
Now.
to is that property right? That's the piece, if I'm
Yeah, it's not-
understanding.
It's not a, it's a fact. I mean, it's not like, I'm not telling, it's something to consider in the sense that when the program is doing things, the department is doing, we're recommending statutory changes, rule changes. It's something that the legal department has considered as a problem or a potential problem that we might need to address with this board. That's all I'm saying. It doesn't have any weight on the sense of testing, but it's just something to consider that if a license is issued, there is a property right in that license. The Supreme Court has mentioned that on multiple occasions, and I have other boards where there's a similar issue. That's the only reason I bring it up.
well, I think that I see the point to the property right to the license number, and I think it would go to their license number, and I think that that's why they have to get a new number.
Well,
And
actually,
that other number's not replaced. That number stands there, and that was their property right, but it's no longer active, and it can't be used anymore.
and that's not accurate. So
not the number.
we can merge those numbers and reissue the old number or the new. It's just a matter of internal process, because in our side for the licensing, they're one and the same person, right? That you don't necessarily start back at high school just because something happened later in life. So in the backside for us, that is the one same person. We can merge the licenses and actually give them back the old license. If we don't, it's more just an internal busy, and we didn't notice it was the same person, right? That's all it is. So, anything else, members? I think if we've got anything on the teams, Dana, let me know. Otherwise, we would need a motion.
My name is Mindy Rutherford.
It's catching her voice. Good. It'll be-
I have one question pertaining to that topic. I got a little lost in the weeds, but is what I'm hearing you say that a reporter could not renew for 5, 6, 7 years, and that reporter had been grandfathered, can then obtain a new license without submitting proof of passing the appropriate test?
I think I have I was formulating the same question in my mind just before you stood up, because that's what I'm hearing as well. And so maybe there's some either that's true or there's some miscommunication in the discussion, but I think I'm hearing the same thing that you just said.
And the definition of an RPR for a steno writer is that they've passed and maintained their certification with NCRA. If they drop their certification, they're no longer an RPR. They can't hold those 3 letters. That's my question. Thank you.
Thank you.
To answer the question, a licensee that has a license through the grandfathering aspect clause, if they're issued a license, if they fail to renew, et cetera, so on, there is a requirement for proof of testing / education. That's the requirement. They have to submit proof that they've taken and passed the exams. Right. That's the issue with that. The grandfathering is just a consideration. If someone were to, take action against the department, that would be the sort of icky aspect of it. I just mentioned.
But we're not. But you all are not approving applications for anyone who cannot demonstrate that they have passed one of the 3 certifications set forth in the board's rules.
But I think what she's saying is you could have passed that test 10 years ago, let it lapse, and then you would have to retest. So are you accepting the old, if I'm understanding correctly, are you accepting the old passage of the test? Does that make sense?
Right. If they've taken the tests or the relevant exam, that would be proof of testing.
Even if it was
education.
10 years ago.
It does. The timeline doesn't matter as long as it's.
But they would no longer have those certifications.
Well, right. But that certification is Are you talking about certification issued by the separate agency?
Yes,
Or our
because
license?
sir, because it's my understanding now to get your state license, you have to have had
Right.
that, but they
Yeah.
have to be current, correct?
To the extent for the certification, but for the license, our rules and statutes don't look at that. They're not looking at that. We're looking at whether they can get the license. Certification through the separate agency, we would have to incorporate. That's why I was saying if legal is looking at this for rules update, statutory update to clarify all of that. Because
there's an oddity in that the rules only require proof of passage of the
Correct.
exam.
That's
Correct.
It doesn't.
I can't. That's what I'm saying. Is I
Correct.
can't look.
You can't
look
go
out
beyond
there.
that. Yeah.
I
Correct.
can look out there for.
So it's actually that the rules don't go far enough, and that I think the rules don't understand the nuance you're describing, which is that your certificate, you take the test and you get a certification from them, and that's good for some period of time. It's good for 2 years, and then you got to retest. And so it's not proof of passage within the previous 2 years, or whatever the case may. Proof of passage and
Correct.
current certification, or what that I could have taken the test 15 years ago, and as long as I took it, it meets
That's what's
what
confusing.
the rule requires.
It's very confusing. I mean, I understand that 100%. It's the proof. I'm looking at the proof of education / testing. That's what I'm looking at in our rules and statutes. I don't have the authority to look outside.
Yeah,
I mean,
that's-
it's an application order comes
Yeah,
to me.
that seems like a real problem.
It is, and that's why we're.
And do we have rulemaking later this year?
Well,
I mean, I guess we can anytime, right?
Yeah, we,
theoretically.
Yeah.
But periodically, you all initiate
yes.
a revision to the rules, and I guess then there's separately whether we want to undertake that ourselves, right?
The board member, I mean, the board as a whole or individual members can bring it up in new business as I think this would be relevant to rule change, and we can take it down as a potential rulemaking project. But this aspect with the education and the certifications outside, we're looking at it from the legal department.
Y'all are going to potentially make a recommendation anyways.
Well, yes. I mean, we're given the opportunity to make recommendations every year to the legislature. So we do that. we do that every year.
So y'all are potentially going to do that as a statutory change rather than as a regulatory change at the board level?
We have requested a statutory change. It's up to the legislature. It's kind of so if we do a rulemaking project, they can't conflict with the statute. So if the statute just requires the testing, and then it's kind of hard to draft a rule with the nuance.
Yeah.
We could potentially do it, and but it's a lot of work. And then the governor's office look at it, the AG's office looks at it, and that's sort of where the legal department, from my understanding, is looking at it right now as a statutory change, because the statutes were created in 2009, and they're outdated in numerous ways. I mean, continuing education and temporary licensure and initial application versus reinstatements and all of that. It's all being looked at, and I do plan on, when I get it to a point where I can sort of combine all the questions and concerns into just one document, presenting it to the board and kind of seeing what you think might need to be changed, because the board is the experts. I mean, you're the experts in the industry. I'm not. The program's not. I mean, so we have to have your input for that expertise. And some of the confusion in the gray areas are spotlighted when an application were to come in, so you don't really know until you see something, and it's like, well, that's an issue that needs to be addressed. And whether do you address it via statute, do you address it via rule? And there's numerous issues that I've seen in my review of the rules that just, even within the rules themselves, don't particularly add up. I don't want to get into it today because I'm not. I don't think I'm prepared to make a statement on it, but I've been looking at it for the past few months, and it's kind of hard to navigate. And then when you look at the statute, you have to make sure that they don't conflict or supersede.
It concerns me when I hear slash between education and testing, because that seems to imply sometimes either or.
No, it's.
Well, it seems to imply it, and it can't be either or. It can only be by testing to get a new license.
Right.
Right, but their point is the test could have been the way the the rules are currently written, that test could have been taken 10 years ago, and it would be valid for purposes of obtaining initial licensure.
And that's the way it is.
Right. That's the way the
it
rules
is
are,
right
current,
now.
are currently
That's the way
written.
it is.
Do we have a timeline on when you think that would be ready?
Well, I don't have a timeline now, but in terms of just me presenting the issues, next board meeting, I could certainly present some issues or to you, and if you have any individually, if you have any concerns, you can work on that on your own time and bring them to and we can use next meeting as a sort of to see where we are and on the same page. And this would be a good rulemaking project, and the best option would be for us all to come together and submit one rulemaking project instead of individual rulemaking projects. So that's kind of where I'm at now. Instead of looking at one change and kind of focused on that, I'm looking through everything to see what else needs to be changed. I've seen multiple things that could be that needs to be updated, in my opinion, but that would actually help me if, next board meeting, and you can email me directly. You don't have to wait. You can email me directly, and I'll just combine everything and present it at the next board meeting for discussion.
Mr. Collins, you got to dumb it down for me. I'm still in the weeds. Is the answer to your question, I think it was the same as all of us, that a person who has never, a licensee who was grandfathered initially, let their license expire, and we talked, both of you, I think, had concerns over property rights, I believe you said. Is the answer to your question yes, currently, that a new applicant or that same LCR can submit a new application using the grandfathering provisions that they obtained their first license in eons ago, and they can use that to get a new license currently under the current rules? Is that what we're saying? And I'll tell you my concern.
I think under the scenario you just described, Hugh, correct me if I say this incorrectly, the person, the applicant,
yes,
with their new application would have to submit, just like everybody else, proof of passage of the NCRA,
okay,
the NVRA, or the AAERT. But the issue is there's no time frame within which, prior to application, that exam had to have been taken. And so if they took it and passed it a decade ago, they could submit that as satisfactory proof of having passed the examination, and they would be granted a license, notwithstanding the fact that it was a decade ago.
I understand that part.
And so, we're having somewhat of an intellectual debate about property rights, but that's not actually, people are not being allowed to use their old grandfathering to get a new license without having to also submit proof that they passed one of those exams.
Respectfully, sir, that's not accurate.
I think what he said is they have to submit proof that they passed the exam to get a new license.
I understand, sir, but respectfully, that's not accurate.
And Sheila, so I don't think we've got a person in mind, but I'm happy to go over that
Okay.
with you, because the board members wouldn't be equipped to answer something in the obscure. But that is the way it should be. There should be
we
an
don't
exam.
know the details
No,
about all
and
600.
that's not what we're
No. I'm not talking about specifics. I'm talking in generalities.
They would need to pass the exam. That answer is correct. So to be licensed. So we can look at more specifics if that's what you have. But the answer that Hugh's given, they would have to have had an exam maybe even 10 years ago, because there's that clash, and nothing in the rule says from 2 years ago for the exam.
Right. So if they've passed the exam ever and they have the proof of passage of the exam,
We
they can
would be
apply
able
for a
to
new license
proceed.
anytime they want to.
Right.
But if they've never passed the exam and they were placed in through the grandfathering provision and they let that lapse past the 6 months,
That shouldn't be there. We should
they
have
cannot,
an exam.
They
Right.
cannot renew that license anymore, but they have to apply for a new license, and they have to submit passage of the
That's what we should
appropriate
see. Yes.
examination.
And what I'm saying is, if there's a specific example of that not happening, then I would have to look at that, because there should be an exam. You are correct. Yes.
But we're just talking about scenarios
Right.
now.
And what we have to follow. Yes.
Right.
Okay, so that I'm abundantly clear. A licensee who was grandfathered in, who has never obtained, irrespective of the method, steno, voice, ER, that has never attained a certification from one or any of those national entities. They've let their license lapse. They initially were grandfathered. They've passed the grace period under that. They, in order to practice court reporting in the state of Tennessee, currently they have to submit a new application, and they can only obtain a new application from a certificate of one of those three entities. They can no longer go back to the old grandfathering thing. Am I correct? And I'll tell you, there's a whole bunch. That's always been my understanding as well.
That's my interpretation.
That's my understanding.
That's what I thought. Yes.
That's my understanding.
This is why I asked for it to be placed on the agenda so that we could prep for this. That's my understanding as well. I mean, that's what I feel like I've said that multiple times. It's I'm looking at the rules in the statute. Initial application, there's a grace period. It expires. It's unlicensed activity, but it's expired unlicensed. It's not never issued a license, unlicensed. So you have to have proof of testing, not proof of retesting, but proof of testing that the tests have occurred and passed. Those are the entries into the licensure.
That's what I've honestly. That's exactly what I've always thought it was too.
It sounds like maybe there's some dispute about whether that's been followed or not. So let's just look into it.
Absolutely.
Like, if you all want to work together or not.
Happy to do that. I have a list.
If you'll look into it and with whoever, I guess it doesn't matter, but there's a concern that that's not being followed. Let's look into it. If we find out that there are examples where people haven't met the applicable standard, then let's discuss it at the next board meeting and decide what we want to do about it.
And that's in fall, December, whatever's on the website, correct?
September,
okay.
I think.
Great.
Yeah.
Thank you. I appreciate your time.
Thank you.
Thank you. Members, if you have anything else, I don't believe we've got anyone on a Teams call with any questions. I'm happy to entertain meeting adjourning.
Make a motion with adjourn.
Second.
Thank you. We have a motion by Ken Mansfield and a second by Stephanie Branham to adjourn our meeting. I've got us at 10:10. All those in favor of adjourning, please say aye.
Aye.
Thank you, members, for your time and the very good conversation today in addressing the complaints. Thank you very much. We are adjourned.